in the first panel about the rise of popularity in group actions and some of the reasons why group actions are a hot topic for 2022. The goal of this panel is to assess some of the day-to-day barriers faced by practitioners and to offer some practical solutions on how to overcome them. In particular, we'll be looking at the growing role of technology and how it's bringing down the costs of pursuing group claims. As the title suggests, we will endeavor to take a holistic approach, focusing not just on barriers faced by lawyers, but also their clients, economic experts, the judiciary, technologists, and other parties connected to the action. In reflection of that broad goal, we have today a diverse range of skill sets represented on the panel. In no particular order, Lucy Pert. Lucy is a partner at Hausfeld and has around 20 years of commercial litigation experience with a focus on financial services, contentious restructuring, insolvency, trusts, and shareholder disputes. Lucy also previously worked for a leading global litigation funder, I believe is present, for several years, which gives her an alternative perspective and has ensured her commercial awareness. Camilla Shah. Camilla is a principal at Oxera, which specializes in providing economic analysis in the context of litigation and arbitration. Her particular focus is on consumer and collective actions. She has advised a number of group and collective actions both in the UK and North America, in both competition and commercial settings. James Oldnall. James is managing partner at Milberg and a commercial litigator specializing in claims against large institutional defendants. I'm sure you'll have one on your lips. He has an in-depth understanding of disputes involving financial markets and products, private equity, hedge funds, data protection, shareholder and companies issues, fraud, and mis-selling. He's presently overseeing 3 group actions under CPR 19.1 and 2 representative actions under CPR 19.6, including the highly watched Lloyd versus Google. Finally, myself. I'll be the chair of today's event. I'm a legal technologist and commercial director at FinLegal, a legal technology company which operates the world's first cradle-to-grave technology solution for claimant management that focuses on the reduction of time spent per client on group claims by using claimant automation, self-service, and mobile-first technology, as well as the world's first totally open litigation funding and ATE marketplace, which helps firms streamline the process of putting funding in place. Brilliant. One of the particular features of opt-in claims is often time-consuming and expensive book building and book administration. I mention opt-in, though from a technology perspective, the process is ostensibly the same, only that it's back-ended and happens over a shorter time frame. James, what have your experiences been, and do you have any learnings from previous book building and management experiences on how to keep costs down and maximize margins per claimant?
Sure, thanks, Lockie. First of all, just backing up slightly into the headline question about the economic viability of claims. I think the first point to note is that often in a group action, you're acting for consumers, and the claims are of small value, which means that by themselves, they're not economically viable. So one needs to bundle them up using one of the mechanisms that was discussed in the opening session this morning. Then once bundled, you have to establish what is that aggregate value and does it exceed the cost of bringing that litigation, together with the cost of funding the costs of that litigation, ATE, book building, all these costs, and leave a respectable residue for the claimants themselves. So that, I think that's the overarching umbrella for opt-in, opt-out. That's the exercise that anyone must do when evaluating the viability of the claim. Turning to GLOs and book building in particular, these are very challenging. The amounts involved are relatively small, and as we heard this morning, there's a psychological barrier to get people to do stuff. You have to motivate humans, get them out of the armchair and do something. A lot of people will be passive even if they're affected. So how do you do that? First of all, you've got to reach people. You have to find them. The SRA prevents you from getting out the phone book, identifying these people and phoning them up. So you have to start with a broad approach. That's the use of media, social media, traditional media, etc. That all comes with a cost. Once you've gained attention, then you have to get action. You have to motivate that person to engage with you, to opt into the process, which generally involves filling in a form, sending some documents, answering questions. That's difficult to do. So what motivates people? You have to ask yourself that question. Often it's money. People like to be compensated. Sometimes it's a sense of injustice. People get cross when they find out. Often you have to educate someone that they have been affected and that there's a way for them to seek redress. And then a sense of community, creating a belief that they're not alone, that other people are facing this issue, and that there's somewhere that they can participate in a broader group to seek redress. And then once you've got people motivated, you need to have them engaged. And that is where Lockie's point of cost minimization comes in. You don't want to have a huge army of junior lawyers answering the phone and receiving these inbound inquiries. You need to have a robust technical platform to intake hundreds or thousands or tens of thousands of clients. And that helps you drive your marginal cost lower, increase margins, and make the claims economically viable.
Gathering evidence and providing quantum in group claims is often one of the most complex and data-heavy parts of the claim. With claimant numbers stretching into the hundreds of thousands and even the millions on some claims, what problems does scale bring, and what can firms do to help manage costs and complexity here? Camilla?
So let me start off. I'm an economist, and economists love data, so the more data, the better. Right? In reality, there's a trade-off between precision and the cost. This was recognised in the Competition Appeal Tribunal, as we discussed this morning, the use of aggregate damages, the use of the broad axe principle, the fact that losses need to be fair but not compensatory. This is also recognised by the approach which is being attempted in Lloyd versus Google, the lowest common harm approach. So scale brings issues, but scale also brings opportunity. So let's start off with opportunity. Opt-out claims, which will most commonly be consumer claims, or likely to be consumer claims. Here, there's likely to be big numbers of consumers, big numbers of claimants. In consumer claims, they're more likely to be common. Consumers are more likely to face similar prices or similar pricing situations or similar harms. In these situations, there's opportunities to estimate using aggregate methods. You can use market-wide data, you can use public domain data, data from the defendants. All of these things can minimize costs by using data that affects everybody to try and estimate something that's similar for the consumers or the individuals affected. Alternatively, you can use survey-based approaches, looking at representative samples of the consumers. This requires commonality or similar issues, and that also requires an understanding of who is in the class or who's in the group. So that leads us on to some of the reasons why these techniques are more challenging with business-based claims, for example, because actually the issues are not so similar. There's more likely to be differences between the class or differences between different claimants or different issues there. This adds in complexity, it adds in burden, it adds in more requirement for evidence, data and analysis, and all of this adds in cost. So, for example, to address non-common issues, you might need to sort of run individual arguments. You might need to, in the case of GLOs, for example, get lots of individual data. And all of this requires lots of engagement and lots of interaction with the individual claimants and lots of evidence. How can this cost be mitigated? So it's worth getting experts involved early, identifying the common issues early and the individual issues. So setting out, well, these are all the common issues that affects everybody, and these are the individual issues which you might need more bespoke solutions. start to identify these areas, and then do they affect the class definition or the group definition? Do you actually need to be a bit more careful in how you define the class such that you can deal with these commonality issues better? Do certain areas of the claim need separate analyses or additional disclosure? And knowing the answers to these questions up front can help a lot with the cost management, as it helps you plan what data you need so you can plan what analysis you need to do. So it's also worth working with quantum experts to anticipate the defendant arguments. By anticipating what the defendants might need or might request, you can then say, well, then let's think about what data or what evidence we need to start collecting at this early stage. There's also the opportunity to use technology-based solutions, and I think, Lockie, you're better placed to explain what some of these are.
Two of the hot topics at the moment are OCR, which is an old topic but is consistently improving. OCR gives the ability to ingest huge amounts of data. If I take an example of something more recent, so a follow-on claim, antitrust, involving huge amounts of historical invoices, OCR might be able to dissect those invoices. So the client doesn't need to sift through. They can just drop the entire bundle. OCR will be able to read through, spot the missing historical invoices, pull that up to the client, remind them to deposit it. But it can also begin to read those invoices, so to see what's happening there, to build up a picture and export that to another system such as Excel for economists to work on it. Or it might even be able to automate some of the early triage, understanding, analysis of that data. So that's one thing, OCR. Another place where technology can be quite useful is if you have disparate parties working on these things. So you have your legal team, your experts, various others. Having a single tool that they can work on, so a workflow tool, means you don't have to keep taking data out of one system, pushing it over to someone else's system, moving it through. Everyone can log in and interact, and that's why web-based systems are so popular now, because you can manage those workflows and keep the data in one place in a consistent form without having to reconcile between systems as you move on and off. Hope that answers your question.
I look forward to using these.
Lucy, speed to market is crucial for any firm launching a claim. This is one area where we have seen the most change, with launch times dropping from months to weeks, partially driven by the replacement of development-heavy in-house IT solutions with modularized web-based platforms. What experiences can you share on how to ensure you are the first to market, and what constitutes quick?
I mean, I think you're right. It is really, the speed to market is important. The issues that arise that will become claims are often in the public domain. And there is a friendly and professional competition between particularly claimant firms to pull the claims together and get to market first. I think in this jurisdiction, we're not used to carriage disputes in the same way that our American colleagues would be, for example. But I think that will come, and Housefeld is involved in a claim before the CAT at the moment in the FX case, and the judgment there might give us some insight into how the English courts will look at carriage disputes. But whatever they decide, I'm sure that who is the first to file is going to be among the criteria that they consider. And I think in the past, the technology and the technological platforms have been a barrier to being able to pull these claims together quickly. I know at Housefeld we've looked at sort of in-house solutions and then scratched our heads and realized that we're not coders, we're lawyers. And that's why the development of these new platforms has been a really welcome development. So I think, now if you have a relationship with one of these platforms already in place, it's really remarkably quick to pull something together. You have the bases, you know more or less what it is that you're going to need, and then you can work with the platform to develop exactly, to tailor it to the requirements of a specific case. which can be done really very quickly. I mean, you're talking, sort of days almost, sort of 10 days, 2 weeks. It's certainly possible to pull it all together, which is a huge improvement on before. So, yeah.
10 days. James, the case of Weaver versus British Airways established a principle that ostensibly clerical tasks cannot be recovered on an hourly rate basis in large-scale group actions. The judgment raised the question not only that the technology exists, but that given that it does exist and has for so long, why have legal teams been so slow to adopt it? Why do you think firms have been slow to adopt technology? And how significantly do you think this judgment will impact future behavior?
Well, to be philosophical, the reasons behind that judgment, I think lawyers traditionally are quite conservative. Not anyone in this room, obviously, we're all cutting-edge tech users and developers. But also the mindset of the billable hour. It's our safety net, it's the business model that people use for pricing their work. And in every firm I've worked in, now 20 years, the conversation has been, we must get away from the billable hour. And everyone says, yes, and nothing happens, and we continue to bill in the same old way. And the clients demand it, and the court demands it, and nothing changes. So I think we're slow to adopt our business model as much as technology. But things are changing. I think lawyers recognize that out there in the real world, developments are being made that allow them to scale and therefore step away from the billable hour as their metric of measurement. And then I think a big change is damages-based agreements. CFAs, of course, you can only make your economic return on the number of hours you put on the page. When you shift to a damages-based agreement where your pay is determined by how much you recover from the client, whether you spent 1 hour or 10,000 hours, you get paid the same. That allows you to bring technology into your business to help you scale away from human beings so that you don't need to put time on the clock anymore.
I think there is just a general fear probably among lawyers of technology as well. I mean, that's sort of, I feel, a feature of our education system that you sort of choose quite early on if you're going to be a sort of techie-minded person or a liberal arts-minded person. And there are some lawyers, obviously, who bridge the gap absolutely brilliantly, but the majority probably don't. And I think it's going to be interesting to see how that changes, actually, in the future as technology and a familiarity with technology becomes more and more important to legal practice, whether we're going to see slightly different kinds of lawyers in the future.
James, should I read from this that you're in favor of DBA and hybrid DBA formats?
I think that they allow you that opportunity to step away from being a slave to your timesheet, and also they align interests between the client and the solicitor. It's not perfect. There are still elements of the regime that need to be worked through the system, and in the wrong case, it can create bad incentives. But by and large, in the group actions I've worked on, a DBA would probably be less of an evil of the two.
Interesting. Everything we've talked about so far has cost implications. Why are group actions so expensive to bring? And what can firms do to mitigate the cash impact of this, Lucy?
Well, I mean, I think James has pointed out one of the reasons, and that's our inability to move away from the billable hour. And these cases are just very large, labor-intensive cases. We've talked about all the quantum analysis and the data involved. It just takes an awful lot of time. And when you're billing by the hour, that's going to add up. And they really are expensive. I mean, the Merrick's litigation, I understand, currently has 45 million of funding behind it, which is just an astronomical number. I think there are some other aspects as well. I think the law isn't hugely well settled. I know we heard in the first session on the various different ways in which these group actions can be brought, but the law's very much still developing and in a fairly nascent stage, and that means that there are a lot of satellite issues that come up as you go through, each of which has to be tried, potentially appealed, and it means that it's taking a really long time for these cases to come to final determination. And again, the length of time it takes increases the costs. Often the group claims, particularly in the CAT, are sort of follow-on claims. So there's been a decision, for example, out of the European Commission, or indeed some other regulatory finding. And I think it's a bit of a misnomer to think, well, liability is being decided already. This should just be easy to conduct the private enforcement. And that's not the case. There's obviously a huge number of issues that need to be determined. The size, the shape of the class, who's eligible, the quantum issues obviously are very important in the role the economists play. And so just because you have a finding doesn't necessarily mean that there's nothing left to do. There's an awful lot to do. We've talked a little bit about all of the admin that comes along with these very large group claims. There's no doubt that the technology is helping with that, but it still is quite sort of time-consuming. And there's there's very, very large quantum at stake, and so it sort of feels like it's worth putting the time in to try to get to the end result.
Yeah, so it's so big that they're difficult to settle. So from a defendant's perspective, when you're dealing with a consumer class, and there are things out there in the world like inflation, playing things long, the client cohort will shrink because people move overseas, they die, they lose interest, they drop out. And so your claim is sort of at its highest when it's filed, and at its lowest 10 years later when you've finally got that Supreme Court judgment that you've been waiting on for 9 months. So it can be extraordinarily advantageous for a defense counsel to take every single point and thereby drive up costs.
Yeah, and in fact, another point, in a similar vein, often these cases are going to the defendant's sort of business model, which I think is another reason that they're going to fight tooth and nail to try and protect the way that they go about doing their business. In terms of what can be done about it, obviously we've got funding. I know we've got a lot of funders in the room, including some former colleagues, as Lucky pointed out. But as we know, these cases are nearly always funded. And even when lawyers are working on a DBA, as James has been advocating, it might well be that you have a funder somewhere in the background. Obviously, in the CAT, DBAs aren't allowed, so CAT claims are more likely going to be funded purely by third-party funders. Now, fortunately, funders really like these claims. They're very large. The quantum's very large, and that helps the funder sort of meet the basic criteria that's, sort of required of the ratio of 10 to 1, roughly speaking, between the damages and the funding required. In individual claims, sometimes that can be quite a tall order with how expensive litigation is these days. But the quantum in these group claims is large enough that it's attractive to funders. There is also, despite what I was saying about follow-on claims not being fully decided, I think there is a de-risking factor when you know that there is a basis of liability that's already been established, and often follow-on claims or claims following regulatory decisions, you can benefit from obtaining documents and evidence in support of the claim. So that's another reason that they might be attractive to funders. And then often the defendants have very deep pockets and are located in this jurisdiction, so there aren't sort of enforcement issues. So I think that, the claims are generally speaking very attractive to the funders. And I think that's a really good way of helping to make the claims economically viable.
Is that a recent change, or have you found that's always been the case?
Well, I think it's recent to the extent that group claims are slightly... I mean, I know there are probably people in the room that will say, no, they've been around for decades, and certainly there have been some group actions that have been around for a long, long time. But the regime in the CAT is relatively new. The use, obviously 19.6 has been around for a long time, but trying to use it as a mechanism for effectively class actions is new. Thank you, James. GLOs, again, have been around for a long time, but I just think the popularity of these mechanisms is increasing. We're talking about them an awful lot more, and really they've only come about relatively recently. So I think for that reason, the funders are more interested in them now. I'm sure had they been around before, they would have been interested in them then too.
I think I saw David Green here earlier, who's been doing them since the 1960s.
I hadn't seen him, but that's who I had in mind. Yeah.
James, you mentioned delaying settlement payment, which is quite a pertinent point because from a technology side, settlement payment is often kicked down the road and treated as tomorrow's problem. We've seen this unravel in fairly spectacular fashion on a number of fairly high-profile claims. How will the arrival of click-and-collect style settlement distribution, and for the audience's information, this is the type of settlement distribution where claimants can click in through a mobile phone and self-serve collection of the settlement payment. Reduce the extent to which settlement distribution acts as a barrier, and how will this impact the types of claims that will become possible?
Well, I think we heard mention in this morning's session of a football shirts claim, and that was going on when I was at Clyde & Co. about 15 years ago, and there was no technology involved in that. People literally had to post in their receipts for their sports top, which of course no one did. And then there was a paralegal sitting in a back room sorting through envelopes and paying out these claims. It was pretty Jeff Bezos in his garage kind of situation. So I think
an OCR opportunity potentially.
Well, yeah,
not to take away work from paralegals.
Well, quite. But you know we've leapt forward massively in people's day-to-day consumption of digital platforms. You know, at that time, people were on Blackberries with side wheels. You know, things have really moved on. So I think it's a game changer to have people being able to interact with their lawyers through portals on their smartphones, and the ability to do your KYC with your, you know, there and then, and it will, any step of friction that can be taken from the process will encourage people to engage. There is a danger, though, that comes with the ease of settlement, and that is often claims are brought against platform providers. And there's a recent famous example where Uber was being sued by large groups of its employees, now they are employees, their drivers, on the basis that they were due holiday pay and overtime. And Uber simply stepped around the litigation and said to any driver, if you want compensation, you have to sack your lawyer and we'll pay you through the app. And so that was the death knell of those cases. For, you know, the funder gets cut out, the lawyer's left hanging in the breeze. And this jurisdiction is going to have to grow up and work out how to deal with that. In Australia, you can't do a settlement outside of the court process once the court process has been established. In America, you have the judge will need to approve a settlement once the court is seized of the action. So that is a room for development in this jurisdiction, because absent it, you have the ability of a defendant to sit there, do nothing until forced to take a stand by the hard work of lawyers and barristers who are in this room, only for them not to be able to pay themselves out of the damages. So that's something we have to grapple with.
And it should be mentioned that compensation payment is prone to exactly the same changes in technology. So where click and collect is available for settlement, it's also available for any form of distribution by the defendant at any stage. So changes in both potentially.
I think it's good to embrace technology, though. My Parisian taxi driver this weekend, when I told him he told me I couldn't pay by card. I said, well, I haven't got any cash. And he said he accepted checks. It's not going to work.
So the title of this group is Making Group Actions Economically Viable. I wonder if you think there's any economic barriers that currently exist that we haven't discussed so far that still act as a barrier to claims going ahead that you would like to see change?
I think there's still a bit of difficulty getting at the outset, getting a claim off the ground, because there's a bit of a chicken and egg situation when it comes to funding. You have to have worked up a claim to a sufficient level for a funder to say, yeah, we want to fund this. And that's work on behalf of both the lawyers and typically the economists. And in these very large claims, that can take a lot of time and it can be very expensive. And the lawyers have to be working on risk typically at that point. And the economists often have to be working on risk, which which can prove difficult later if you want to use the same economists as your Part 35 experts, for example. So that is, the funding is fantastic. There is seed funding nowadays, but it's not always that easy to come by. The terms are often quite, not as favourable, shall we say. And even for the seed funding, understandably, you have to show that you've got to the kernel of a case. So that's something that still, I don't know what the answer to it is, but it's still a bit of a conundrum, trying to get everybody to work on risk at the outset.
Yeah, and that's made worse with the idea of carriage disputes. If you've got multiple people racing for the same claim, then even if it's a good claim, you might not be the first, or you might not be the first to get the funding or the first to launch the claim.
From my perspective, I think it's procedural fragility and procedural immaturity, which is our greatest problem. We've touched on many of these points in today's session and in this morning's session, but we've got a patchwork of procedure available. The competition regime, 19.6, GLOs under 19.1, none of them really talk to each other. There's not a huge amount of crossover. So a defendant can and will often, at any certification hearing, say that the claimant has brought this claim under the wrong regime. If 19.6, it should be a GLO. If GLO, why not? Why are you wasting my time? This should be 19.6. I think we need to harmonize the regime and provide decent framework and guidelines for the right case to be under the right regime, such that those arguments get taken away or addressed. Secondly, I don't think the court is particularly well equipped. Going into the weeds here, but the ability for people to CE file a GLO with multiple claimants on it, the technology is really rudimentary and crumbling. That needs to be addressed. So the lawyers are using whiz-bang technology that the court is struggling to emulate. And we need to have judges who are specialists in this area. The carriage dispute that we had in your case, I'm sure you can't comment, but it's a ridiculous outcome that both parties turned up and said, hey, judge, we're here for a fight. Tell us who won. And the judge says, no, let's save that for another day and waste everyone's costs and expenses. We need judges who understand the situation, understand the economics of these claims, and are prepared to take bold stances. The same happens in GLOs, where there's a quasi-carriage dispute with multiple claimants. You can have a solicitor from Liverpool with 4 clients competing with a London-based solicitor with 10,000 and having equal audience. I mean, these things have got to change. There needs to be a grown-up conversation with the judiciary to ensure that they field the right team and approach these cases in the right way. Sorry, that's my hobby horse. I'll sit down.
Yeah, very interesting. So I might end with something that perhaps lawyers aren't always friendly to, which is a request for a yes or no answer. With reference to your particular areas of expertise, yes or no, have technological changes had an impact on your ability to pursue more and a wider variety of group claims? Camilla?
Absolutely, yes. There's better data retention from businesses. So businesses actually see data as a strategic asset. They hold data on their customers. They hold data on their transactions, on their competitors. They actually store this data in more and more friendly, usable formats for their own business, which then helps us use that data when we need to. And this allows much more straightforward scoping of claims or very early analysis of claims when it's in much better formats. The historic claims, they're still going on where you have thousands of invoices, hundreds of thousands of PDF, wonky invoices with a coffee stain on. And you're trying to understand who sold what to who in which year, and it's just so time consuming and costly to manage that kind of data, whereas actually in this going forward, I look forward to 20 years from now when these types of invoices don't exist anymore. Everyone's got online databases.
Almost a yes or a no, but you're not a lawyer, so
definitely yes.
Lucy, yes or no, the impact of technology, and also what would you like to see next in the space?
I'll forgive the slightly leading nature of the question and the fact that I don't dare say no to you. So the answer is yes. It is genuinely yes anyway. I will expand upon that, not least because we have a little while left. But I mean, I think the use of technology is going to help reduce timeframes and make things a lot more economical. Because really, a lot of what I hope that technology will be used to do is to replace paralegal hours, for example, and administrative tasks that we've been struggling to know how to deal with them. We have low-cost centres offshore or outside of London. Or we have temporary staff coming and going, and it's been quite a difficult sort of nut to crack. And I think actually the use of technology is going to really change the way that we use non-qualified, non-legally qualified staff, and that will inevitably reduce costs. You know, in terms of what are we seeing what will we see in the future? I mean, more of the same, I think, and you know, finding ways to help. I don't know. Well, I don't think there will come a time when lawyers won't be required at all, but I do think that technology is going to assist us in the more mundane aspects of the work that we do. And, you know, I mean, we've already seen huge changes in disclosure, for example. And I think that will just continue. And we will, I hope, be left with the more interesting aspects of our job, which is, you know, being trusted advisors to our clients.
And James, same to you. What has it helped? And is there anything it hasn't yet helped with that you would like to see?
Yes, technology's helped, and it's opened up the possibility of large-scale opt-in consumer-based actions, which wouldn't work without it. And that is what, like I was talking about before, the one's ability to reach a broad audience. Social media has revolutionized the way in which a lawyer can market their services, in the same way that elections can be influenced and Donald Trump can make his way to the White House. You can segment your audience with a high degree of precision so that you know that the message is getting to the right people. And then once you've got hold of those people, you can intake them and onboard them. You know, when I was primarily focused on private practice, you know, an engagement letter would take a junior associate maybe half a day to get right, and we're signing up, you know, 500, 1,000 a day. Technology is the only way you can do that. So a commoditized product perhaps helps. And then horizon scanning. Maybe it's about technology, but I think the technology is here and will bubble away. I think what we really need to see, I'm climbing back on my hobby horse, apologies, but I think we'll see some of these cases win, and I think that will change the dynamic. We're still in very early days, and you know, although David Green's been doing it from the 1960s, the big profile cases that are in the machine at the moment, the likes of Merrick's and so on, consumers will start getting distributions through your technology platform. People will start to see it working, the system working, and I think that will be a voice for change, both from consumers and the funders who will be replete with cash, who will be lobbying for better access to justice and for better accommodation from the courts. And the lawyers will learn so much and will grow up and will be less afraid of standing up and being vocal about the need for access to justice for consumer claims. So that's my vision of the future.
A noble vision. We only have a few minutes left, so I wonder if we would put it to the floor if there are any questions that anyone has for our panelists.
Thank you. There's a couple of questions that came through for the panel from the Slido app. The first question is from Luke Harrison at Kyden Harrison, who was on our last panel session. So thank you, Luke, for the question. He's asking the panel, what do you think will be the likely outcome of the case of Bott & Co. Ryanair, in which the Supreme Court judgment is expected on the question of whether solicitors have lien on settlement?
You can take that one. What does Luke think the answer to that question is?
Should we hand a mic over?
Okay, another question is, do you think more commercial firms should and will be looking at group actions in the future? Perhaps after Wednesday.
Well, it's going to be really interesting to find out what happens next week. I mean, and we'll hear James's thoughts on it, but I would have thought that even if the Supreme Court decision doesn't go the what I would consider to be the right way to allow the use of 19.6, that's not going to be the end of the story. I think clever lawyers are always going to find a way to bring these claims. I'm right there with James on his hobby horse. I think actually the situation in this country is untenable, and I think there are other jurisdictions, particularly in Europe and elsewhere, that are coming forward with class action regimes that are actually fit for purpose, and that we're going to start losing out, and we won't be seen as a jurisdiction in which to bring these sorts of claims. That said, I think that they're here to stay, and they are an important way of seeking redress for consumers who simply can't access the judiciary at the moment because it's just too expensive. So I imagine other firms will be involved. We've seen something of an influx of US class action firms into London recently, and I don't see any reason why that won't continue. So we'll see.
Yeah, I think for commercial firms to dip into class actions, I think it might be difficult. It's probably more specialised than one might think, and the challenges of getting a commercial firm with a compliance department comfortable with the speed that one needs to move in order to access the case and get it to market. I think it's going to be a challenge for commercial firms, and dabbling in this space can be quite dangerous. So let's see. I think it would be difficult for commercial firms to go wholesale into the space until it matures and there's more scope for stability.
Although the defence firm's obviously going to have to be on the defendant side. So
Yes.
Great. Were there any questions from the floor at all? Anyone? No? Any final thoughts from the panel before we close for a coffee break?
Wrapping up early. Our thunder was stolen because we were going to talk to you all about what GLOs are and 19.6 and everything, but the first panel covered it so ably that we dropped it from our agenda.
Nothing wrong with getting to coffee quickly either.
Okay, well, thank you very much. That's great. Thank you, Lockie. Thank you, James, Lucy, and Camilla.